Right now, thousands of people are sitting in California jail cells, not because they're criminals, but because they suffered a mental health crisis that the police or the system refuse to recognize. If you are facing charges today, and you know deep down that your behavior was driven by depression, anxiety, trauma, or some other form of mental illness or addiction, you are currently caught in a processing machine that only wants to give you a conviction and a permanent criminal record. But there is a secret exit ramp that most people, and even some lawyers, completely miss. It is a law in California that can stop your case in its tracks and get your charges dismissed, and even help you legally seal your arrest record as if it never happened. My name is William Pernik. I'm a criminal defense lawyer in California and a certified specialist in criminal law. Today, I'm going to show you exactly how to use Penal Code Section 1001.36 and what you risk losing if you let the system treat your mental health crisis like a crime. Most people think that once a district attorney files charges, you only have two choices: go to trial or take a plea deal. That's a myth. In 2018, California created a third option called mental health diversion. Think of your case like a train moving towards a cliff. Diversion is a switch in the tracks. It allows you to pause the criminal case entirely while you get the help you actually need. If you complete the program, the train doesn't just stop. The tracks disappear. The case is gone. But here is the first hurdle. The system won't just offer this to you. You have to fight for it. Now that we know what the exit ramp is, let's look at the checklist that you must meet in order to qualify. To get onto this exit ramp, we have to check 4 primary boxes for the judge. 1, you must have a recognized mental health condition. This isn't just stress. This is depression, anxiety, post-traumatic stress disorder, bipolar disorder, schizophrenia, or many, many others. You have to have nexus or connection or link between your mental health condition and the charged crime. This is the most important part. We have to show that your condition played a significant role in why the incident happened. The law defines it as something that either causes, motivates, or contributes to your criminal actions. You also have to agree to follow a treatment plan and supply the court with a plan that's going to meet your individual treatment needs. Finally, the judge must believe that you are not going to be a danger to the community while pursuing treatment on an outpatient basis. If we hit these 4 points, the law says the judge can grant you diversion. But here is the tension. The district attorney is going to fight us because they want a conviction, especially if your case has a victim who is against you getting a dismissal. They're going to tell the judge that you're a threat or that your condition had nothing to do with the crime. And here's my solution for how you can resolve that tension. The best way to defeat the district attorney's public safety argument is by being proactive. Most lawyers wait for the judge to tell them what to do. We don't, and you shouldn't either. We always work to build a professional treatment and stabilization plan immediately. By the time we actually go to court or start bringing your motion, we aren't just promising the court that you're going to get help. We show the judge that you're already doing it. We turn the district attorney's threat argument into a recovery reality. This moves the judge from a place of fear for public safety to a place of confidence in your success. We also use experts who specialize in clinical psychology or drug addiction in order to explain the role that your mental health played in your decision-making and how it affected your judgment and your behavior, instead of relying simply on a letter from your therapist or general practitioner. People often ask me, William, does my specific condition count? Here's the secret. The law is incredibly broad. It doesn't just cover mental illnesses like schizophrenia or bipolar. It literally includes virtually any mental disorder identified in the DSM-4, Diagnostic and Statistical Manual of Mental Disorders, that doctors use. This includes things like postpartum depression, severe social anxiety, or even impulse control disorders. If it impacted your brain's ability to make a good decision, it's likely going to be a valid why for the court. There are a couple of exceptions to this rule, like pedophilia or antisocial personality disorder, but most conditions will qualify. Now that you know you qualify, we need to talk about the expert trap that kills most otherwise successful cases. You cannot just walk into court and tell the judge you have anxiety. The court will likely require a report from a qualified mental health professional. The trap or mistake a lot of people make is using a general doctor who doesn't understand the legal requirements of mental health diversion under Section 1001.36. If your expert writes a weak report that doesn't clearly link or connect your condition to the crime, the judge is simply going to deny your motion in 5 seconds. You also only get one shot at this first impression. This is why it's really important to use specialists who know how to speak the language that the judge needs to hear. The next important requirement is nexus. Nexus is a legal term that really means a bridge between your condition and your charges, and it's super important to establish it in court. For example, if you're charged with a theft offense, we don't just say you were depressed. We show the judge how that depression led to a cognitive fog or an impulsive breakdown where you weren't thinking clearly, where you weren't being yourself. When we build that bridge, when we establish that connection, your theft crime stops being a crime of greed and it starts being a symptom of an illness. That is exactly how you win the judge's heart and mind, and sometimes your prosecutors too. So what happens when you finish the program? This is the grand payoff. The best part about this program is that under PC 1001.36, once you complete your treatment plan, which usually lasts 12 to 24 months, depending on whether you're charged with a misdemeanor or felony, your judge must dismiss the charges. But it gets even better. The law also requires the court to seal your arrest record. What that means is that in the eyes of the law, the arrest essentially never occurred. When a future employer asks you if you've ever been arrested or convicted of a crime, you can now legally say, no. You get your life back, your career back, and your reputation back too. But in order to get there, you have to first survive the trenches of the legal process. Here are 3 rules you must follow if you want to stay on the path to dismissal. Number 1, silence is your only shield. Do not try to explain what happened to the police at the scene. They're trained to see a confession, not a mental health crisis. Let your lawyer and your doctor do the talking later. Number 2, compliance is king. If the judge grants you diversion, you have to be perfect. Picking and choosing medication or missing therapy appointments can give the DA the excuse they need to put you back in a processing machine. Number 3, the digital paper trail. Start documenting your treatment history now. Document your past diagnosis. Get every receipt, every doctor's note, every prescription. All of these things are bricks in a wall that we're going to build in order to protect you. You also need to be prepared. The district attorney is likely going to object. They're going to argue that the crime was too serious or that you are malingering. That means faking it to get out of trouble. This is exactly where the tension is at its highest. We need to resolve this tension by providing collateral evidence. That means statements from your family, your employer, or even your friends who saw the change in your behavior. We show the judge that the why is real and that the DA's objection is just part of the machine. We demonstrate that in fact you were mentally affected around the time of the crime and that with treatment you've done so much better and made a huge difference. Now, for my professional clients, doctors, nurses, lawyers, other licensed professionals, diversion is your lifesaver. Because the case is dismissed and your arrest record is sealed, it often prevents the disciplinary boards of your profession from finding out about the incident. Even if they do find out about the incident or you are legally required to report it, avoiding getting a conviction is often the best way to protect a license that you worked for a lifetime to earn. It is not a loophole. It is a clinical solution for a clinical problem. The same is also true for my immigrant clients who are not US citizens. Getting your case dismissed after treatment instead of getting a conviction that could result in you losing protected status or getting deported is a really big deal. You do not want to screw up that opportunity. I want you to imagine waking up a year from now. The court dates are gone. The fear of a prison cell has vanished. Your record is now clean. And more importantly, you are healthy and stable. You are not a criminal. You are a person who faced a mental health crisis or an addiction crisis, and you came out stronger and healthier on the other side. That is the power of my method, and that is the power of PC 1001.36 diversion. You don't have to be processed. You don't have to be a victim of the machine. You get to survive it. You get to triumph. If this video helped you understand the missing dimension of your case, please hit the like button and subscribe to my channel. Please share this video with someone who needs to hear that they are more than a case number. My name is William Pernik. Let's find the truth, let's fix the problem, and help you stay out of trouble. Visit us at perniklaw.com.